Good morning, everyone. Thank you for joining the webinar on India's personal data protection regulation. My name is Mona Lisa Bhagat, and I am a manager with Riskpro. We shall wait for a couple of minutes for the other participants to join in. Thank you. Good morning, everyone. I would like to give you a brief overview of our company, Riskpro India Ventures Private Limited. Riskpro India is a risk advisory consulting firm. We are in this business since 9 years with our head office in Mumbai, and we have our presence in 7 other cities. We have served more than 500 clients and are a team member of 60 plus with more than 10 strategic partners. We have our four main business verticals: risk advisory and assurance, technology, training, and recruitment. In risk advisory assurance, we conduct GDPR audit, SSA 18, IFC reviews, risk-based internal audit, IT audit, etc. With respect to technology, we provide software for legal compliance management, internal audit software, third-party risk management, etc. through our technology partner firms. In training, we conduct in-person and online trainings on topics like ERM, risk assessment, anti-money laundering, information security, as per the company requirements. With respect to recruitment, we provide full-time and part-time internal auditors and virtual risk managers for audit and risk requirements. Today's webinar will be for 60 minutes, out of which 10 to 15 minutes will be for our question and answer session. During the webinar, all the participants will be on mute mode, that is listen only mode. If any participant would like to ask any questions, they can write in the questions tab and the speaker would take it during the session or at the end of the session. If any of the participant is facing any difficulty in viewing the screen shared or maybe listening to the presenter, would request you to kindly log in and log out log out and log in the webinar. Sorry. If it continues, kindly drop a message in the chat box and our technical person will look into the same. Today's webinar is today's speaker for the webinar is our Rispro's founder and director, Mr. Manoj Jain, and Senior Vice President, Information Security Risk Advisory, Ms. Sucheta Upendra. I would now hand over the presentation to Ms. Sucheta. Hello, Sucheta.
Thank you, Monalisa. Am I audible now?
Yes, thank you.
Is the screen visible?
Yes, Sucheta.
Okay. Thank you everyone for taking time out for this session today. Our today's topic is Personal Data Protection Bill 2019, key features and implementation challenges. So let me start with the brief background. What is data privacy? It's a right of individual to have complete control over their personal information. In India, there's a popular belief that we do not have, before this PDPB came in, we did not have any personal data protection, any laws related to personal data protection. So these are some of the key milestones which are related to data protection laws. Information Technology Act was passed in year 2000. It was amended in year 2008, which actually started talking about personal information and body corporates' responsibilities towards that. It also spoke about certain fines, but it's only in year 2011 that the rules of sensitive personal data and information were released to give more clarity on what can be considered as personal information, what can be considered as sensitive personal data and information, and what are the safeguards which organizations need to implement for this particular data. In year 2017, landmark right to privacy was a landmark decision about right to privacy was there. It was also known as Justice Puttaswamy judgment. So that judgment explicitly mentioned about existence of information privacy. Followed by that, a committee was formed to discuss about various issues related to data protection, and a first draft of the personal data protection bill came into place. And it was modified later, amended draft came into place in 2019, which is with Joint Parliamentary Committee, and the findings and the recommendations would be discussed in upcoming parliamentary session. So our objective is to discuss this particular bill and implementation challenges related to the bill. So the bill is divided into 14 chapters, starting with applicability of the bill, definitions, obligations of data fiduciary or data controllers, what are the grounds of processing, what is the law related to personal data and sensitive personal data of children, rights of data subjects or data principal as known in this bill, transparency and accountability measures, and so on and so forth. We will not get time to discuss all these 14 chapters, so we will discuss only the key features and focus primarily on the implementation related issues. So applicability of the bill, yes, it will be applicable for organizations in India who are collecting, disclosing and share personal information which is being collected, disclosed and shared within India. It will be applicable to the processing of personal data by state by any Indian company uh, which is incorporated or created under Indian law. Would it apply to non-Indian companies? Yes, it would apply in certain conditions. So if they're carrying out business within India, it would apply to them. If there's a systematic activity services being goods and services being offered to citizens in India, it would be apply. It would apply to them. It would also apply to them if profiling of data principles is one of their activity. So central government may exempt from this applicability of this law the processing of personal data of data principals who are not within territory of India pursuant to any contract. Uh, the definitions of this bill, it talks about uh, different things. So there is there's a large set of data which organizations collect. Small set of it is personal data or personally identifiable information. And another subset within personal data is sensitive personal data, which is defined by this particular bill. In addition to that, there is something called as critical personal data, which is a new terminology, which is different from many other data protection bills, which this bill had introduced. And what is critical personal data? It is yet to be notified by the central government. So we are hoping to get more clarity on this in based on the findings and recommendations of Joint Parliamentary Committee. And what is personal data? So our bill defines the personal data as data about or relating to a natural person who is directly or indirectly identifiable, having regard to any characteristics, traits, attributes, or any other features of the identity, whether it's online or offline. So this is one important. This is an important keyword: online or offline, and it shall include any inference drawn up from such data for purpose of profiling. The bill also identifies what is the sensitive personal data. So it includes financial data, health data. It also this identification of sensitive data is also in line with sensibilities of India or socio-political culture in India, and as the reason even caste and tribe is also included as the sensitive personal data in this particular bill. Critical personal data, we still don't have clarity. What would that include? And any anonymized data will not be considered as personal data. Many of us would be familiar with a term called data subject. So data subject is called as is referred to as data principal, the person whose data is being collected. Data fiduciary or data controller. So this is the organization who determines purpose of processing of this personal data collected from this data principal and means of processing. Why would data be collected and how it would be processed? So that is determined by data fiduciary, and data processor is the entity who actually processes the data uh, on behalf of data fiduciary as per instructions from the data fiduciary. So the processing would include accessing the data, modifying it further, generating insights based on the data, storing the data, uploading the data. So any activities which you can perform with the data, that would be covered under processing. In addition to that, this bill also talks about significant data fiduciaries. What is significant data fiduciaries and how is it determined that any data fiduciary is significant? That would depend on personal of volume of the personal data processed by the organization. How sensitive is this data? So if any organization is processing primarily the sensitive data classified as sensitive, that might be considered as significant irrespective of probably volume or the turnover. Turnover is another criteria. Risk to the data subject or risk or harm to the data principal from processing. So that would be another criteria which would decide whether the data fiduciary is significant or not. Use of new technologies, artificial intelligence, machine learning, and any other technologies, cloud-based technologies for processing, and any other relevant factor which is related to personal data processing, which would give large power to the fiduciary, would decide whether the data fiduciary is significant or not. So how would such fiduciaries ensure transparency and accountability? What this bill stresses a lot on transparency and accountability by the data fiduciaries. So how is it ensured? Significant data fiduciaries would have to mandatorily register with the Data Protection Authority of India, which is again another recommendation by this bill. Uh, they would have to, or not only significant, but all data fiduciaries will have to comply to privacy by design. They will have to consider data privacy right from design of the product or design of the service till it is offered to the consumer. Till it is offered to the end users. Data audits. This is again for significant data fiduciaries. They are subjected to the data audits as mandated by Data Protection Authority of India. Data protection impact assessment. What is the impact of your processing on the data principle? How would they be affected? So the formal data protection impact assessment is another way to demonstrate the transparency and accountability. Record keeping or data inventories. What is the data you are processing it? How are you processing it? What is the origin of data? Where is it stored? How is it processed? Whom it is shared with? When it is deleted? How it is deleted? So entire data flow and record keeping of that is expected to be done. Grievance addressal. So if data principals have any queries or if they have any complaints, if they have any requests, these fiduciaries are expected to have a mechanism to address the data principals grievances. And finally, appointment of data protection officers for significant data fiduciaries is it's another mechanism to demonstrate the accountability. So as I mentioned earlier, this bill stresses a lot on accountability of the uh, accountability for processing of the data. What are the key features? So key features, like any other data protection law, this bill is based on certain principles. It expects that any data processing is done based on the lawful purpose. A clear ground of processing is identified for processing of any data. Organizations should identify what purpose they want to process the data for, and limit the data collection only for those purposes. Organizations are also expected to give notice to the data principals about their data processing practices, about what data is being collected, how it is being processed, who are the third party it is being shared with, who is organization data protection officer. Quality of the data, accuracy of the data which the organizations are maintaining, they're expected to give right to the data principal to ensure that data is accurate, to correct the data if required. Restriction on retention. So the organizations cannot retain the data forever. They need to have a retention policy in place, and there should be a basis for retention. So if the organization says that we would retain this data for 10 years, there has to be a reason. Is it a statutory requirement, or is it contractually mandated, or is there any other reason? So retention policy is expected to be in place with the reasons for retention, with the justification for the retention period. And accountability. So as discussed earlier, there are various ways to demonstrate accountability, right from records of processing, data protection impact assessment, privacy by design, having a mechanism to address the grievances. So these are the primary principles on basis of which this bill is based on. In last slide, we discussed about lawful basis, or establishing the basis for data processing. So what could be the basis? So one is consent. Data principals consent for processing the data. Of late, there have been a lot of discussion based on WhatsApp privacy policy, based on the consent, how they are they giving the option for us to consent for sharing consent for sharing our data. So consent is not yeah, thanks to that discussion, consent is not really new to us. It's a lot of us are aware about consent. The bill talks about the way consent has to be taken. The consent has to be informed. There has to be an explicit consent for processing the sensitive data. Bill also talks about functions of state. So if government or state is providing you certain function. So one example is a recent vaccination drive. They would have to collect certain personal data for that. So functions of processing of the data for providing certain services to the data principals to the people of India. That's another basis. A prompt action in case of medical emergencies, that's the third basis, which can be used for processing the data. Compliance with law or order of the court, in case there is a legal requirement to process certain data, in case there is an inquiry of fraud, inquiry of certain criminal cases, then to comply with that, certain data has to be processed. Employment purpose. So this is something new. GDPR or some of the other data protection law didn't talk about employment as employment as explicitly. They didn't identify it as explicit ground for processing of personal data. But Personal Data Protection Bill of India, it says that employment is one basis for processing the personal information, and reasonable purposes or legitimate interest of the organization. But this would depend on how would it impact the data principle as well. Manoj, would you like to give any examples on reasonable purposes or legitimate assessment? Legitimate interest?
Yeah, Sucheta, so thanks. I think these grounds of processing are very important because ultimately a company has to decide what is appropriate in terms of processing of user data. And if they are processing without determining what is grounds of processing, then actually the implementation of that processing will not be appropriate. So taking an example of marketing being a classical example of legitimate interest or reasonable purpose. Now, in this case, what is considered reasonable? Do I contact a small set of people for marketing? Do I contact a large set? What is the mechanism I use? Do I send emails? Do I send SMS? Do I send it in the morning? Do I send it in the night? So all these are different elements that a company has to consider as to what is considered reasonable purpose. Now, doing one thing right at a specific point in time, maybe in the morning versus in the evening or in the night, changes the whole dynamics of a reasonable purpose. So here we are really talking about whenever we do processing, if you don't have any other grounds of processing, is the reasonable purpose an appropriate ground for processing? And if not, then essentially we cannot do the processing, which is a classical thing about lawful basis, is that if you don't have any one of these areas or grounds of processing, then processing is not permitted. There could be many other legitimate interest or reasonable purposes apart from marketing. It could also be using the information for connected services, things like maybe communication of the services, communication of the upcoming products and services, as long as it is reasonable. So the word reasonable is the one that we need to really focus on and try to interpret whether it is appropriate for a user. And essentially, we have to use the user's perspective whenever we use this grounds of processing. Because if we are only going to consider our own interest, then this will actually be in breach of grounds of processing. So yeah,
Right.
I think that's it's again an area which is open to a lot of interpretation, and it's an area that requires a lot of discussions. The evolution of the regulation over time, over the next 6 to 9 months or 12 months, will tell us how companies are adopting this and whether they are fairly doing and transparently doing the processing.
Right. Thanks, Manoj. Another key feature is data principal's rights. So data principal have a right to confirm what data is being collected about himself or herself and access that data. So the organizations, in case the data principal request, organizations are expected to give the summary of what data is being processed and confirm that they are processing the data based on data principal's request. Right to correction. So it's related to the principle of data quality. That any data principal would have a right to correct their data which is being collected by the organization. In case any data is outdated, they can also request to erase that particular data. Right to data portability. So the organizations are expected to, based on data principals request, organizations are expected to provide features to download the data in a readable, machine readable format and share it with the data principal, which data principal may or may not decide to provide, to give it to another service providers. And finally, right to be forgotten. So if data principal thinks that any data has to be deleted, is no longer required for getting the service, or any data is collected without their consent or being used wrongfully, they definitely have a right to request the organization to delete their data. And the organization would have to delete that data. They would also have to tell their other partners whom the data is being shared to delete this particular data. So these are the 4 rights which Personal Data Protection Bill talks about. Um, This bill also talks about Data Protection Authority of India, who is responsible for protecting interests of data subjects, who is responsible for monitoring and enforcing provisions of the Act, specifying code of practices. So there are a lot of gray areas in this in the bill. The implementation guidelines are not included over there. So best practices, code of practices to for certain things would be rolled out by Data Protection Authority. Prompt actions in case of data breach. So the bill talks about reporting the data breach. In case data breach is reported, what actions has to be taken, supporting certain Data Protection Authority of India would be responsible for that. It should also maintain database of significant fiduciaries along with the respective data trust score. What's data trust score? We'll say in subsequent slide. And finally, the examining data audit reports. So as we have seen earlier, significant data fiduciaries might undergo data audits. So from such data audits, what are the findings? What are the, if the practices are compliant to the data protection bill or not, reviewing it, taking appropriate actions is responsibility of data protection authority. And finally, enforcing the penalties for violation of personal data protection bill. So GDPR talks about supervisory authorities. Its Data Protection Authority of India is in line with that. Data trust score. So this is one requirement which is quite different than other data protection bills. So data trust score can be any score. It can be high, medium, or low, or it could be a numerical value which is derived based on organizations' commitment, management commitment towards data privacy, organizations' knowledge about data privacy, the controls, the safeguards which they implement, a review mechanism, governance mechanism, and redressal of grievances of data principals. So what the bill says is that significant data fiduciaries, when they are subjected to audit, the auditor can also come up with this data trust score, or they themselves can come up with the data trust score, and they have to include it in their privacy notice. So which is quite different as compared to other data protection laws which we are familiar with. So there is an organization called FDPPI, Foundation of Data Protection Professionals of India, which is a Bangalore-based foundation, but there are members across India who's working on a mechanism for calculating this data trust score, mechanisms for coming up with the data audit, how these data audits to be conducted. So various such organizations would be contacted and could be communicated. They could be proposing their way of coming up with data trust score. But currently, this FDPPI is one of the leading organizations who's doing that. Compensation and penalties, it's again much talked about. The offenses, there's one interesting thing is about offenses of re-identification. So re-identification of data and processing of de-identified personal data, that is considered as one of the offense. So what if the organizations for their legitimate purpose they will have to re-identify the data? We still don't know the answer how this would be interpreted and considered for compensation and penalties. So with this we move on to the points which we have to consider, organizations have to consider for the implementation. One of the important point is privacy notice or consent. So what is typically considered included in privacy notice? What personal data, what is the intention of the notice? So its intention to answer some of data principles questions like what personal data about me is being captured, where would this be stored, how will it be used, with whom this data will be shared, will I have a choice to withdraw my consent to delete my data, will my data be secured, what kind of safeguards the organizations would be using, and whom should I contact to resolve my complaints related to my data or use of my data. Okay, so typically, I mean, this and many more, the privacy notice is expected to answer these questions. The organizations are expected to publish their privacy notice whenever they are offering the services. So one problem in India which we might face is that do we need privacy notice in multiple languages? Privacy notice is expected to be read by data principals, is expected to be easily understood by the data principals. In that case, would English be the only language or should it be in local Indian languages? In European Union, many of the countries are using various technologies like Ibunda or TermSpeed to come up with privacy notices in their own, in the country specific language. Would we have to adopt to certain technology? So this is one point which organizations would want to consider. Consent fatigue. So most of us download on our mobile, we use many apps. We use app for payment, we use app for apps provided by cab aggregators, uh, apps related to apps such as Google Maps. So each of these apps would give us privacy policy, and they also ask us for the consent. But considering the privacy policies are huge, considering that there are multiple places we will have to give the consent, a lot of data principals are, it's quite possible that they would get consent fatigue. So obtaining this explicit consent, obtaining the informed consent would be quite challenging unless we use certain innovative use for getting the consent. Then there is a parental consent for processing the children's data. Even that could be challenging how to get and manage that consent. This bill talks about usage of consent managers. Using a framework or platform to get the consent, get informed consent, manage it, store it, give features of withdrawing the consent to data principals. So instead of writing to the organization, they can use these platforms to withdraw their consent or reconsent. But there's still not much awareness of these consent managers. Everybody has to understand what are the consent managers and how they can use it, and they do not have to consent for everything. So this kind of awareness, it would take quite some time, and implementing these platforms in using appropriate technologies for implementing it could be quite challenging. Would you like to add anything over here, Manoj?
Sucheta, I think we should discuss maybe the first point about privacy notice in multiple languages, as well as the fact that a lot of the user community that we have possibly could be in villages and small towns. So
Yeah.
as it is, the whole concept of privacy is very basic there. So
Yeah.
the challenge becomes even further, trying to do just to comply with the regulation, just having privacy notice in English. Now I'm sure a large population is still not able to kind of understand all those legal concepts, and then apart from that we have a language issue. So apart from multiple languages, is there also a need to communicate it in a simple manner, as well as even communicate it to people who don't understand or cannot read, to communicate it to them verbally, saying that, okay, once you do this activity with us. So for example, maybe it could be banking, it could be financial transactions, or it could be any engagement with the customer, openly telling them that, okay, I'm collecting your documents, your identification, your biometric, whatever, and this is what we will do with that. Now, even that could be considered a good form or a demonstration of accountability with respect to privacy. So language is one element. Beyond that is people who actually cannot actually engage with you in terms of the readability or ability to read information. So these are very, very relevant points. And in a country like ours, it becomes all the more challenging. And then the other fact is even trying to sync up and maintain various versions. Legal language itself has so many issues. You talk about Google's consent, Google's privacy notices. They may not be as clear, as transparent as everyone likes, and there were fines with respect to that. So you imagine now we are trying to convert that English into 15 other languages. Are we going to have translation loss? Are we going to have understandability loss with respect to different languages and privacy notices? So yes, the challenges are quite a lot for India, and specifically the fact that it's thus far we have not really considered privacy in a very big way. If you look at Europe, Europe has been under data protection for the last, I think, almost 20 years or so in different forms. And PII privacy has been very prevalent in the Western countries. Everyone just keeps talking about it. The regulations have just come in, but the implementation or the adoption or the accountability happened a lot earlier. For India, it's like everything is going to be starting in the next few months, and that makes it all the more challenging, not just for the companies, for the people to consume this privacy framework. We're used to sharing information all the time, but in the Western countries are not so used to sharing information so openly. So the question may be also that do companies need to be ready, or do the users need to be ready with this framework? Because although the regulation really drives the companies, unless the users are actually concerned about their privacy, the companies will not really give it a serious thought when it comes to data protection.
Right. What I
Yeah.
also think, Manoj, is one aspect of this is innovation. Will a lot of companies would have to innovate new ways of getting the consent or demonstrate the transparency and accountability. This bill also talks about sandbox, which can be used for innovation, trying the innovative platform. So probably such activities would gain traction once this bill becomes an act.
Yeah, definitely. And I think those steps, we just have to see which types of companies adopt it faster in a more comprehensive way, and which one of them would be ready to pay the fines and do the business in the usual way. So a lot remains to be seen as to how the innovation will actually kick in, and how much seriousness there is on the regulation.
Yeah, right.
Yeah.
Okay, then there is all the organizations when we talk about privacy, the first point is data which is collected from the end users, from the customers. But even internal departments like HR collect a lot of data. HR typically starts with recruitment, onboarding of employees, development, talent development of those employees, overall managing the performance, the salary disbursements, and finally exits. So each of these places, they collect different set of data. For recruitment, they might be collecting a lot of data from the platforms or job portals. The data could be name or contact details, past experience. Once they decide to offer a job, they would also collect data about past salary, which might include, they might ask the candidate to share their salary slips. They might ask the candidates during onboarding. They again would collect the data which is related to their residence address proof, the PAN number, Aadhaar, passport details, the emergency contact details, data which has to be updated in forms like Employee Provident Fund. Some of the data during development, they might also transfer to a group of their international group of companies or other internal teams or external trainers. There are also chances that the performance details and the increments related details, they are shared if certain for managing the salary, any external agencies are used. For managing the payroll processing, external agencies are used. The data would be transferred over there as well, and they would organizations would collect updated contact details when the employee is exiting. So within the organization, the employee, if we are not even considering the customers or end users of the organization services and products, within the any organization, lot of data about the personal employees, and many of it could be the sensitive data, the financial data, the bank related data, the salary specific data, the biometric data. A lot of it would be confidential, and it would be collected by start with the HR team, but it could be given to different teams. Biometric data would also might also go to the admin team or IT team. Salary processing data might go to the third party payroll processors. So organizations would have to think about every function, what data they are collecting, whom they are sharing it with. There are chances that the organizations are using a cloud-based HRMS platform. In such cases, this data, most of this data would be shared, would be uploaded to the cloud-based platform. So which might be a problem related to data localization. If the cloud is not residing in India, okay, if then would the sensitive data would go would it have to be stored outside India? In that case, do the organizations have to take explicit consent, or should they just segregate the data based on the category? Should they re-engineering their business processes? If they allow the data to go outside India, or if they have to mirror certain data, would they be able to implement same privacy and security controls to manage that? So this is another problem which many of the organizations face. So the point is, it's not only customers data, it's not only end users data, your own employees data, or it could be vendors data. If any organizations would be collecting and processing, and they would have to think about the workflows, what data they have been collected, and how it is being processed, which platforms it is being processed with to comply with this bill, which could be quite complicated, because they might have to change their technical infrastructure, they might have to change their business processes. Oh, here. Would you like to add anything, Manoj?
Yeah, just on the previous slide, when it comes to HR data, so this clearly is a challenge. What we have experienced over the last 2-3 years in international companies adopting data protection, GDPR, and various regulations, we realized that there's always a focus of external stakeholder. That means your customer, your consumer, the person who's using your services. But very little focus is given to internal, like employees you mentioned. So HR could be the next big thing, possibly even above marketing department in terms of data collection. Marketing department would still have simple data. It's just contact details, email, just to try to get new business. So there's direct marketing element. But when it comes to HR, we are really taking the most complex and most sensitive data. In fact, pretty much, once the definition of critical data is come in, there's a good chance that some of that information could be with HR versus any other department. So the reason why HR becomes a very complicated department is because it collects an array of data points, starting from regular data, sensitive data, possibly critical data. And the other reason is it's not just your employee base, it is actually your employee base plus your prospects, people who applied, people who have left your organizations. So the whole concept of data deletion, can you apply it properly to employees who have left your company? Now, if you don't do that, you're again sitting on a large volume of data. So consider a company where you have 10,000 employees. Now, in order to maintain a 10,000 employee workforce, you may be at least running 100 times resumes, running into crores of profiles that come in, and likewise, the churning that happens over time, that data still retains in the organization. So with that view, essentially what's happening is this data set becomes highly complicated. So, and in India, again, the focus is you take the onboarding process is collecting so much information, whereas a typical company in, again, the overseas countries would be collecting the bare minimum that's required for employment, for recruitment, for interviews, and whatever. Here we take it for granted, and then we collect excessive information. So these are some of the clear challenges, and unless the mindset changes, every function pretty much is going to break the whole system, be it HR, be it marketing, be it the product team, the development team. So there are clearly 5 to 6 areas which a company has to focus on, and proportionality could be one concept. That means start from the most important, most voluminous data and move down. But we have to address every area, not just the external. Putting a privacy notice on the website is just not the answer to the whole thing. That's just one piece of the overall accountability and adoption of the regulation.
Right. Another thing I would like to point out over here is since last year, after the pandemic broke out, many of the organization took proactive steps and started certain services like counseling services for their employees. For that, some of the organizations have also created apps which employees load. Some of the apps are internally developed by their IT team. So while doing that, in future the IT teams would have to consider about or the development teams would have to consider about privacy by design requirements. Uh, so as Manoj has said, even for internal data, we to demonstrate accountability, we would have to take a lot of these steps, including privacy by design. So what is finally, how do you ensure that you are ready this for this new bill? So one way to so can we use a checklist like determining if your organization acts as a data fiduciary or data processor? That could be the first step, followed by reviewing and recording the data processing activities, internal as well as external data principles, identifying the grounds of processing, reviewing consent management practices and privacy notice, defining the process to address data principal rights, defining the process for data breach management, reviewing the security safeguards, appointing a data protection officer. So a lot of us, I mean, we tend to use this checklist based approach. So is this yeah, this is certainly helpful. It is good to start with, but is this sufficient? This checklist might still not help us in addressing certain challenges. Like, where do we start from? uh, Manoj spoke about starting with the department which is collecting more data, large volume of data. But is there anything else we can start with? What would be the right approach for our company? What is the proportionate investment? So we might have to invest in a lot of tools and technologies to ensure the data privacy, to demonstrate our accountability and transparency. So what kind of investment is required? Who would approve it? On what is the basis on which this can be approved? Coordination with business and support functions. With which functions do we consider? Which functions do actually collect major data? How do internal functions work? What is the data flow, or what is the workflow of those internal processes? So we might want to put a lot of controls in place, but those controls come with the expenses. There is a cost for implementing any control. So how do we balance it with business needs? If we say that we will not process, we will not profile any data, would it really work for our business? Because our business might work based on the machine learning, what we learn from this data or what we predict based on this data. So in such case, how do we balance our business needs, especially in case of marketing or advertising organizations? What are the technical measures which are mandatory, which can be done away with? What kind of governance structure should be in place? So our traditional chief information security officer, should that person be a data protection officer, or do we give the data protection responsibilities to the legal team? In that case, would legal interact with CISO? What would be the interfacing mechanism? How would we govern this entire privacy program? So a lot of these questions, every organization would face when they are implementing or they are getting ready for the personal data protection bill.
Yeah,
So yeah.
Go ahead.
So I was saying that so we need a framework which would address such questions. We would give us detailed guidance on how certain things be done. We have from the bill, we know what needs to be done, but we need some guidance on how certain things need to be done. Yes, Manoj?
Yeah, true. So of course, there are a lot of questions that still remain in terms of lack of clarity in the regulation and India-specific challenges, India-specific demographic challenges, the population, the size, everything is of large scale, the largest democracy in a sense. So, will these bring unique challenges to India? That has to be seen. Also, we can just try to understand in terms of what would be some of the challenges that companies might have. So if any of you on the call you just want to share your views, we can try to explore some of those challenges. You can put it through the chat and we can discuss those. Apart from that, I'll have one specific slide that I just want to kind of highlight. Apart from this, so this is the poll when it comes to what is your biggest challenge in implementing India data protection framework? So there could be various challenges, but let's see what the audience thinks could be some of the biggest challenge for them. So we'll just keep it open for a little while and then kind of see how the results come out.
Yeah, sure. Shall we move on to the next slide in the meanwhile? Okay.
The responses are coming in.
Oh, okay.
So let's just see how it goes.
Okay.
So while the responses are coming in, one of the things that will become a challenge for India would be people who have knowledge in these concepts. This is a scarce area in terms of the technical knowledge that is required, the knowledge that's required to assess an individual situation, a particular circumstance. So that is clearly one challenge. The other challenge, as I mentioned, would be the consumer-oriented, the other side of the story. If the other side is not willing or not ready, then how much can companies do to overcome that barrier? So that's another challenge. But anyway, the poll essentially, as it's collecting the information, about 46% are saying that there's lack of clarity in the regulation.
Right.
And 26% say that privacy as a concept is not well appreciated by the businesses. So that kind of makes sense. Lack of clarity is clearly one of the barriers, at least to kickstart or to advance prepare for this regulation. This has been in the works for the last several years, but until we know exactly what to do, we cannot start. And that is one of the challenges that people are facing with respect to that. The other thing I just wanted to kind of quickly bring together. So let me just share my screen. I'll take over and then continue.
Sure.
Okay. So the other point that I thought maybe worth exploring or discussing is again is the overall accountability aspect. So accountability on its own as a term means very little. It's just like a dictionary word with a lot of meanings least understood. But when it comes to companies, when it comes to data protection, when it comes to regulation, it assumes a specific meaning. So let's take a recent example of WhatsApp and the updates to the privacy notice. So what was really happening in this case? I mean, was it something wrong? Did they not follow the regulation? I don't think that's the case. Essentially, what the privacy notice update was it was relating to trying to overcome the purpose limitation, trying to use data in other group companies, trying to use data in multiple ways, and it was trying to broaden the reach and the interaction or the engagement of the users. So, but the companies, sorry, the users didn't like it really a lot, and the government also stepped in and says that okay, we actually want you to withdraw these privacy updates because it's an intrusion, rights to privacy, and many other terminologies were used. So the moot question here is that was it wrong? So when a company starts off by collecting data and it says, I will use your data for this, and then that particular purpose is very well understood and users like it, they start interacting and they share everything about the company. After 1 year, the company changes course. Then what happens? The users are stuck to the service. They have shared everything, and now they are left in the lurch in terms of okay, suddenly everything changes. So now the privacy advocates are essentially saying that there should be some provisions to shield citizens from random modifications of terms of service by organizations, by intermediaries, all these things. So can the regulation actually bring in something saying that if you make this principle, if you make this consent requirement, if you make this lawful basis, then you cannot change it for a specific period of time because a user is engaging with you with that anticipation. It's very similar to employment. Now, when you hire somebody, you give them certain promises, you give them certain roles. Now, they just assume that you wanted to hire somebody as a manager, and then you start giving them a role totally unrelated, something that they don't like. How would an employee react in that case? So this is a very similar situation. There's nothing wrong legally. Nothing has gone wrong. The companies have right to update their privacy notices, but it's a question of accountability and responsibility and transparency. If you had intended to do something like this in the future, you should have either hinted out or you should have kind of brought some elements of that into the picture so that users are forewarned about that, and of course a lot of other challenges. So yeah, Sucheta, any thoughts on what the regulation can do or what users can do when it comes to random changes of privacy notices in the middle of the business?
I think organizations will have to be careful before they update their privacy policy. Uh, they will have to roll it out, take the data principles in take the data principles in confidence, announce what are the changes and the reason for doing those changes. They cannot just take the data principles for granted. So
Yeah.
that's one thing all the organizations need to keep in mind.
Okay, great. If you have anything to add, we can basically discuss that, or we can go into Q&A or just explore what questions people have. So I'll anyway hand over this to you.
Yeah, I just have one point about the framework. So, Data Security Council of India has come up with a framework of data privacy, which is called as Data Privacy Principle, which could help us in addressing a lot of challenges, which would tell us how to build a data inventory or what are the points to be considered for building a governance. How do we, technically what are the points to be considered to be able to do technically be able to address data subject rights or monitoring the privacy incidents, what are the privacy enhancing technologies to be used. So this frameworks provides a detailed guidance on how to's of the data privacy. So these organizations may consider using for implementing elaborate data privacy frameworks within for themselves. Um, Right. I think we can open for questions now.
Okay.
We just have.
Yeah. So a couple of questions that people have asked. So let's just try to go through some of them, and please do send across your questions if there's anything. Let's see if we can take them up now or later on. So one of the questions is companies based out of EU, will they have to comply with GDPR as well? So this is a question that has been asked. So
Yeah,
clearly companies that are, yeah.
Right, companies who are out of EU, they have to comply with GDPR. If they are offering goods and services to citizens of Indian data principles, or they are profiling the data of Indian data principle, data principles in India, then they have to comply with PDPB also. So there would be a situation where organizations would have to comply with multiple data protection regulations depending on where they are based at, whom they are offering their services to.
Yeah. And can GSTN be treated as sensitive personal data when on the opposite side GST law mandates public disclosure of GSTN? So we're essentially talking about the actual number itself, the GST number.
Yeah, so finance data, the definition is pretty much in detail.
Yeah, and the other point
Yeah,
also
so
about this is it's more about personal data with respect to an individual. So generally,
yeah,
business-related information is broadly not under the scope of various regulations. It has less intrusive behavior in it. Ultimately, everything revolves around how much of an impact it has on a particular data principle and with respect to specific consumers.
yeah, right. And there's a
Um,
question
yeah,
which
go ahead.
talks about should data fiduciary issue notices to data principals? Yes, data fiduciary are expected to publish their privacy notices, which data principals need to understand about it.
Does the Act have any mandatory retention period of personal data?
No, so
You want to
Act
take this?
talks about, yeah, Act talks about having a retention policy. It doesn't talk about mandatory period. So we need to have a retention policy, but we need to justify the retention period for each type of data we are handling.
And when is the bill likely to go live? Any indication?
Uh, there's going to be a discussion in next parliamentary session. I think 29th, the discussion would start. Joint parliamentary committee would present their findings, the recommendation. As per one of the news in last year, Meenakshi Lekhi had mentioned that they have come up with many recommendation and couple of additional clauses. So we'll have to wait to see what are those amendments suggested, and when would it be approved. But whenever it is approved, organizations would get time for some time, typically 6 months to 1 year, to enforce it, because they would have to make a lot of changes. But no, I mean, we don't have a specific date on this bill to get approved. We can just hope that in upcoming parliament session it is discussed and taken to conclusion.
One question is, do we need to have both data protection as well as records management policy? So the answer is yes. Essentially, the privacy framework comprises multiple types of documents, multiple types of policies and procedures. So while there is an overall data protection framework that talks about roles, responsibilities, governance, the different aspects of the data protection, records management would essentially talk about how you're going to handle the record, the data classification, how long you're going to retain it, how you will delete it. So the documents definitely become critical, and records management would be required in order to address storage limitations, data minimization, data deletion aspects. So there's a lot of documents that are generally expected to address different areas of the framework, the data protection framework.
Okay. There's a follow-up question on last question about data privacy notice. So if the data privacy notice, the fiduciary need to give it to processor. So no processor with fiduciary would have a contract with processor about what data has to be processed. Fiduciary is the one who would decide purpose and means of processing, and processor would process the data on fiduciary's behalf. So there would be a contract, there would be instructions on how data to be processed. There would be in the contract, there could be clauses related to right to audit, or clauses related to safeguards which need to be implemented, clauses related to third party transfer, but there is no notice as such.
Yeah. Another question is how often should list of consent managers be reviewed? Gauri has asked this. I'm not sure. Does it mean the people whom we take consent from, or the actual consent managers, the centralized intermediaries? Sucheta, what is your opinion on this?
So the bill doesn't mandate any particular period, but at least we should there needs to be. I mean, depending on how much data you collect, you can decide how frequently you have to review the consent which is received, and if there are any requests related to withdrawing the consent, that needs to be addressed immediately. That you cannot keep them pending for the next review. Would you like to add anything?
Yeah, I mean, what is the point about consent managers? So how often should the list of consent managers be reviewed? I think that's not correctly worded, I guess, right?
Consent managers would help us in managing the consent. I mean, seeing the consent, seeing who is withdrawing the consent. So how often would actually depend on how much data you are processing. So if there is a organization which is into lead generation, generating marketing leads, then they should review it more often. Whereas if there is an organization who is employee specific consent, you do not have to review it more often. So it would depend on what are you collecting consent from, what is the volume of the consent you would collect, volume of the what is the volume of the processing, why are you collecting consent. So it would depend on that. That's what I think. I hope I addressed the question.
Okay. The other question was whether multiple data protection policy required to comply with regulations of different countries. So this is a very common problem for many of the frameworks in risk and compliance. There are multiple regulations affecting the same area of concern. So in this case, the best approach is to have a very country neutral document instead of using definitions from India data protection, using definitions from GDPR. You may want to either put them as annexures or make it a high level document which addresses the concepts, retention concepts, the limitations, deletion, data inventory, data mapping, without necessarily mapping out to regulations and clauses and things like that. Because over time, if you are a global company, you'll end up complying with at least 8 to 10 regulations. And then you'll have a massive challenge of maintaining 10 different sets of documents. So ideally integrated frameworks work best, which means one set of documents which everyone can adopt and use and understand, and trying to keep the common themes. Wherever there's a unique theme, of course, you might have to call it out in the documents.
Yeah. In fact, those who have already put in efforts and processes, technologies in place to comply with GDPR or CCPA, they might want to extend the same to incorporate these requirements. So they might have some head start for this particular bill.
The other question, which is kind of interesting, is since one of the grounds for processing is employment, does it mean that specific consent from employees is not required? So, Suchita, you want to take this point? Because we have employment as a specific grounds of processing, do we not need consent from them for anything?
But the bill also talks about explicit consent for processing sensitive data. So if there's any sensitive data about, let's say, health records, a lot of organizations, for applying leave, you might want to, the employees might have to submit the medical record or report from the doctor or something. So for even from employees for processing sensitive data, the consent would be required. So during when you are giving the employment contract, probably these consent, I mean, there should be a separate employment, the privacy policy specific for the employees, and that should clarify on what data is being collected, and the consent has to be explicitly taken.
Maybe one last question, and then we'll have to stop because the questions are coming in, and this is clearly an area of quite a bit of concern. So let's just take what is meant by re-identification and de-identification. So this one, actually, I'm not so certain I understand this. Do you have any understanding on this?
De-identification is removing the identifiers from the data, which can be used for generating certain intelligence, not using the actual data, removing the identification. The bill talks about offense related to re-identifying. So de-identified data, if you re-identified, from that you make out who is the data principal, it is considered as offense. But again, there's not much clarity. Is it intended only for the data breach, or is it intended for anything else also? So yeah, I don't have answer for re-identification.
Okay, I think let's thank everyone for their time. We have definitely crossed 10 minutes over, and there are several questions which we will respond hopefully through emails as far as part of the follow-ups. And we are likely to, kind of repeat this with more information, more updates after 2 to 3 months. By then, there will be more clarity, and of course, more updates would come in. So thank you, Sucheta, for the time, and thank you everyone for joining the session.
Yeah, thank you, Manoj. Thanks a
Thank
lot,
you.
everyone.
Thank you all. Thanks. Bye.
Bye.
Thank you, everyone.